Well, the first stage is a very practical stage, which is that both the people concerned need to be sure that they understand what their mutual financial circumstances are and that they're clear as to what the value of their various assets, income, pensions are. It's only once you're confident that you understand that really you should be able to start negotiating. And then the second stage is a more legal question, which is to understand what the options could be for achieving a financial settlement, taking into account your particular circumstances.
But what does the law actually say should happen?
Well, there's no formulaic approach. What the statute actually says is that all the circumstances of the case should be taken into account. And there is a range of factors a court will have regard to, from the age of the parties, how long they've been married, how much financial resource they have, whether they have children, and so on. So there is no formula and there's no straightforward percentage approach. The main issue, and usually the trump card, is what the needs of those parties are. So both of the parties and any children that they have will have a need for housing and they'll have a need for income. And it is only once those needs have been met that any extra capital or income that there is around may be subject to what's called the sharing principle, bearing in mind what it would be fair for each of those parties to share, taking into account what they've contributed to the marriage.
And is 50-50 the normal outcome?
No, 50-50 is often not the right outcome. It may seem an obvious outcome and to a layperson may seem a fair outcome. But as I say, the usual, most cases are dealt with on the basis of the needs of the parties. And if, for example, there are a party, one of the couple have young children, it may be that more than 50% of the assets is needed to house those young children whilst they're under the age of 18.
And for someone just about to go through the process, what sort of practical advice would you give me?
Well, I think anybody contemplating a financial settlement and getting to the stage of negotiation should really make sure that they sit down with their solicitor before the negotiations start and get some clear advice from them as to what their best case, worst case and mid case outcome could be from a court, because that's the area within which they need to negotiate. And people need to have realistic advice at an early stage after the financial disclosure stage to make sure they know what the ballpark is and therefore what they can expect both from the negotiation and if the case ended up in a court hearing.